One element is to copyright your name, both your true name, the all caps version, and all its derivatives. A second element is to use UCC filings to take control of your strawman, a process that is often called redemption. Note: depending on who you employ to guide you through your redemption/secured party process, the common law copywriting of your name will be included in the UCC1 filing. The plan was well on its path by 1933. Massive registration, surrender of property through United States agencies, including the state subdivisions, was assuring that the United States and its officers would get rich beyond their wildest expectations. All of this was done without full disclosure. If a remedy was available, and the people chose not to or failed to use the remedy, no charge of fraud could be sustained even in a common law court. The United States only needed to provide the remedy. It was not required to explain it or even tell the people where the remedy could be found. If the people did discover their remedy, the United States had to honor it and release the registered property back to the people, but only if the people knew they had a remedy, and only if they requested it in the proper manner. In 1933, the United States put its insurance policy into place with House Joint Resolution 192, which provided that the United States subjects and employees could use any type of coin and currency to discharge a public debt as long as it was in use in the normal course of business in the United States. For a time, United States notes were the currency used to discharge debts. But later, the Federal Reserve and the United States provided a new medium of exchange through paper notes and debt instruments that could be passed on to a debtor's creditors to discharge the debtor's debts. That same currency, Federal Reserve notes, is used to discharge public debts. In the 1950s, the Uniform Commercial Code was presented to their states as a means of unifying the generally accepted procedures for handling the new legal system of dealing with commercial transactions and fictions as though they were real. Security instruments, commercial paper, replaced substance as collateral for debts. Security instruments could be supported by presumptive contracts. Debt instruments with collateral and accommodating parties could be used instead of money. Money of exchange and the need for money was disappearing, and new money was being created, i.e. money of account, created by bill of exchange, and a uniform system of laws had to be put in place to allow the commercial venue and the courts to uphold the security instruments that depended on commercial fictions as a basis for compelling payment or performance. By 1964, most all the states had adopted the Uniform Commercial Code, which is merely a codification of accepted and required procedures all people engaged in commercial activities must follow. Presumption became a big part of the law. Without giving a degree of force to presumption, the new direction in enforcing commercial claims could not be supported in their courts. The profits from all the registered things, such as land, cars, guns, children, etc., had to be put into a constructive trust for the benefit of the owners. If the profits were put into the general fund of the United States and not into separate trusts for the owners, the scheme would represent fraud. The profits for each owner could not be commingled. If the owner failed to use his available remedy, fictional credits held in a constructive trust account, fund, or financial ledger, to benefit from the profits, it would not be the fault of the deceivers. If the owner failed to learn the law that would open the door to his remedy, it would not be the fault of the deceivers. The owner is responsible for learning the law, so he understands that the profits from his things are available for him to discharge debts or charges brought against his public person, debtor strawman, by the United States. The Uniform Commercial Code is that remedy. Names are nothing more than property. No one is his trade name, all caps spelling of your name, nor is anyone his true name. A name can be trademarked, service marked, and copyrighted by the owner for the purpose of restricting others from unauthorized use and just enrichment at the expense of the owner. If you are 18 or older, you, the flesh and blood man or woman, own your name and you may copyright it under the common law. After copyrighting your name, no one will be able to use your name to enrich themselves without first gaining your agreement. Let's say a police officer pulled you over and wanted to give you a ticket. You can warn the officer that he is using your copyrighted name for financial benefit and that it is a violation of your copyright. You should also inform him that to persist in the use of your copyrighted material without your permission carries an automatic penalty of $500,000. You have just formed a legally binding verbal contract with the officer. If the officer then persists in using your name without permission, he has breached the contract. You then have the right, under UCC Article 9, to default judgment against them using non-judicial proceedings to collect on the debt that he owes you. This is a very powerful concept that can be used in dozens to hundreds of ways. The copyright notice also establishes a private contract between you and your straw man whereby you offer services to the straw man, for example, signing documents for it, in exchange for certain considerations. You become the creditor over your straw man who becomes the debtor to you. You can file a UCC financing statement to receive official government acknowledgement of this private contract. This UCC is a financing statement which creates an interest in property that secures payment/performance of an obligation by your strawman for the services you render to it. This UCC filing establishes a seniority position of claim over the other creditors who may make a claim based upon date and time of filing. In this way, if any party ever attacks your strawman's assets, you will have a superior claim on it. U.S. Congressman Charles A. Lindbergh Sr. from Minnesota, who opposed the Federal Reserve Act, revealed this before the U.S. Congress sometime during his term of office between the years of 1907 and 1917 to warn the citizens. We bankers must proceed with caution and guard every move made, for the lower order of people are already showing signs of restless commotion. Prudence will therefore show a policy of apparently yielding to the popular will until our plans are so far consummated that we can declare our designs without fear of any organized resistance. The Farmers Alliance and Knights of Labor organizations in the United States should be carefully watched by our trusted men, and we must take immediate steps to control these organizations in our interest or disrupt them. At the coming Omaha Convention to be held July 4, 1892, our men must attend and direct its movement, or else there will be set on foot such antagonism to our designs as may require force to overcome. This at the present time would be premature. We are not yet ready for such a crisis. Capital must protect itself in every possible manner through combination, conspiracy, and legislation. The courts must be called to our aid. Debts must be collected, bonds and mortgages foreclosed as rapidly as possible. When through the process of the law the common people have lost their homes, they will be more tractable and easily governed through the influence of the strong arm of the government applied to all central power and imperial wealth under the control of the leading financiers. People without homes will not quarrel with their leaders. History repeats itself in regular cycles. This truth is well known among our principal men who are engaged in forming an imperialism of the world. While they are doing this, the people must be kept in a state of political antagonism. The question of tariff reform must be urged through the organization known as the Democratic Party, and the question of protection with the reciprocity must be forced to view through the Republican Party. By thus dividing voters, we can get them to expand their energies in fighting over questions of no importance to us, except as teachers to the common herd. Thus, by discreet action, we can secure all that has been so generously planned and successfully accomplished. Look within for the solution. You are the solution. Pull the rug out from beneath the parasitic bankers and their system of governance designed to manipulate money and disrupt the free market for the benefit of special interest groups that are adverse to freedom, liberty, and love itself.